Hi, Ed Gudeman of Gudeman Associates Financial Law Group. We're bankruptcy attorneys, and we have offices located in Royal Oak and in Warren, and we would look forward to meeting you if you are under financial stress. One of the things I'd like to talk about today is how to have a successful Chapter 7 bankruptcy. Very often people come into our office and they say, am I going to get the discharge? Is this going to work? Well, the way of having a successful Chapter 7 bankruptcy is to tell the truth, because all your pleadings and everything you do is under oath. And the courts have ruled that is provided you are not in bad faith. In other words, you haven't lied and you've told the truth and disclosed all your income, all your assets, all your debt, you are very likely to get that discharge. It's very, very rare that somebody filing a Chapter 7 doesn't get a discharge, and it's only in instances where there's a perception of a lack of truthfulness in the petition and in testimony that's given at what we call a 341 hearing, which is a hearing conducted by the trustees, and typically the only one hearing that you have to go to in a Chapter 7. So what you should do to have a successful Chapter 7, hire a competent attorney who knows what they're doing and is familiar with bankruptcy. Many attorneys are not familiar with bankruptcy and they shouldn't be handling the cases. The other thing is tell your attorney the truth. Comply with what I call a prime directive. Tell us all your income, all your assets, all your debt. If you're ever sitting at home sometime working on the paperwork that you have to do to prepare for a Chapter 7 and you think, I wonder if my attorney needs this. The answer is always yes. Provide your attorneys with full information, and the likelihood of your having a successful Chapter 7 and getting your discharge is significantly enhanced. And next, you have to go to that 341 hearing. That's a hearing conducted by the trustee. It's mandated under the code. It's not by a judge. It's just by the trustee or their counsel conducting that meeting. And provided you do that, you tell the truth, the meeting is likely to be conducted, and that's the only contact that you're going to have with the bankruptcy court other than filing your petitions. So, if you do that, then and there's anything to follow up with from that 341 hearing, providing additional documentation and things like that, you got to do that too. But if you do, you will receive your discharge. It's a process that overall, from start to finish, takes about 5 months. You file, 35 days later in the Eastern District of Michigan, you have that 341 hearing, and then the trustees usually take from 10 to 20 weeks to get the case wrapped up and get the discharge issued. If you have any questions about this, give us a call. The number is on the screen below, and you can set up a no-obligation consultation, which means you can come in, meet with an attorney. If you retain us, that's great, and if not, there's no charge.